I think they're all. We should talk about it. We should talk about it.
I will ask it at the end. All right, ladies and gentlemen, good afternoon. One housekeeping announcement. I make this in many of the rooms and ask all the other moderators to do the same. If you are walking around with clickers, for the voting thing, people beside Nicole has a dedicated one because she likes to vote all the time. Please return it downstairs to the tables in the Madison room in the big room, okay? Secondly, I just want to tell you that of the sessions where we've had votes, there are now 3 in which the needle has moved perceptibly. And in case you haven't been to those sessions, one involves Iran, where the question was, if you were a member of Congress, would you vote for the agreement? Where the number of people voting for it went up precipitously after the discussion. The second was in this morning's panel on Islam, where we asked the question of whether or not boots on the ground, American boots on the ground, should be placed in order to defeat ISIS. And the number rejecting that went up significantly after the discussion. I think basically on the view that nothing would matter. Thirdly, in the GMO conference, on genetically modified food, I think basically under the influence of Stuart Brand, huge spike and don't regulate. Anyway, we're here to talk about the Supreme Court, about which some of you know something. There are those 9 people down in Washington. We have Jeff Toobin, who writes about the court for The New Yorker, and quite brilliantly, I might add. And Jim Zirin, who's a practicing lawyer, actually, in New York, and has written a really compelling book called The Mother Court about the Southern District United States Federal Court in Manhattan. Also a good read, as is 9 and Jeff's other 15,000 books.
6.
Between friends.
Exactly.
Okay. So let me begin just with a quick introduction. Assessing the performance of the court, of course, basically depends on where you sit, where you stand, what your personal ideology is. For those who agree with the court's vision as expressed in the couple of latest recent terms, namely decisions that essentially say that the race question in the country has been solved, that unlimited amounts of money donated to political campaigns cannot possibly lead to governmental corruption, that religious owners, now come on. We know your political leanings generally, but that religious owners of closely held corporations and prayer-leading town council members are the new oppressed minority, and that women, in the earlier words of Justice Kennedy, fraught with emotional consequence as they enter a Planned Parenthood clinic, are not being harassed, but merely counseled by anti-abortion protesters. If these decisions charm you, then all of the change, so to speak, wrought in this term was very positive. But those of you who live in a different reality, for those of you who live in a different reality, this court continues to be, I guess I would say, startlingly out of touch. And that is what I want to say as a beginning thing. In other words, this question is pretty much very contentious, depending on what you bring to it as your political leanings. I don't know, and it'd be interesting to hear Jeff and Jim speak about it, whether or not any decision in recent years has been so compellingly written that it actually caused large members of people to change their views. In any event, the first, what we're going to start with is Jeff talking in an overview kind of way about the court, where it is today, where he thinks it might be headed, recent trends and possible future trends. Jeff, thank you.
Michael. Hello, everyone. Nice to be here. Beautiful day, Kent, Connecticut. What could be better? I don't know. Okay, let's talk about the Supreme Court by the numbers a little bit. We've got 6 men and 3 women. First time in history there are 3 women on the Supreme Court. There are 6 Catholics and 3 Jews. First time in history there are no Protestants on the Supreme Court. There are representatives of 4 New York City boroughs on the Supreme Court. Sonia Sotomayor is from the Bronx, Antonin Scalia is from Queens, Ruth Ginsburg is from Brooklyn, and Elena Kagan is from Manhattan. Tragically, Staten Island is unrepresented on the Supreme Court, but perhaps future appointments will address that. Anyway, those are some, I think, interesting facts about the Supreme Court. But here's an important fact about the Supreme Court. There are 5 Republicans and 4 Democrats. You now know most of what you need to know about the United States Supreme Court. There are 5 Republicans and 4 Democrats. The system was more or less set up this way. You know, the party that controls the presidency and controls the Senate generally controls the Supreme Court. We've been in a period of close balance between the parties, and the Supreme Court reflects that. And I don't see that as any real grounds for criticism. I think this notion that the Supreme Court should be apart from politics is a folly. It's always been a folly throughout American history. Now, there are certain aberrations, and the individual justices matter, and the arguments in individual cases matter. But by and large, this is a court that reflects the politics of the president who appointed the justices. Now, this is, I think, as Michael started to in his introduction, it is a generally very conservative period on the Supreme Court because of one thing, because of the disappearance of moderate Republicans. Moderate Republicans have disappeared from the United States Congress. They've disappeared from the United States Supreme Court. If you look at the Supreme Court from the 50s up to the present, you see that moderate Republicans held the balance of power for many years, whether it was John Marshall Harlan II during the 50s, Potter Stewart during the 60s, Lewis Powell in the 70s, Sandra Day OConnor in the 80s and 90s. They are all gone from the Supreme Court, and the court now, by and large, reflects the contemporary Republican Party. There were 2 very major decisions of the past year, and I'm sure we're going to talk about them at some length today: the marriage case and the Obamacare case, King versus Burwell. Both of those cases were won by the liberal side. I think there are interesting, discrete reasons why the liberals won that case. Briefly, the first is Anthony Kennedy. Anthony Kennedy, for whatever reason, is a generally conservative justice who has a real sympathy for the cause of gay rights, and he has written a series of gay rights decisions going back to the sodomy case in 2003, and so that's why there was a 5th vote in the marriage case. King versus Burwell was a simply appalling and disgraceful lawsuit that even John Roberts couldn't support. It was an attack on Obamacare that was literally conjured out of 4 words that appeared to contradict the entire rest of the Affordable Care Act, which John Roberts, being the good lawyer that he is, being the representative of a court that didn't want to throw off 6 million people from health insurance because, in effect, of a typographical error, had to vote the way he did. And I think it's an illustration of just how absurd that case was. Even Anthony Kennedy, who has a deep loathing for the Affordable Care Act, joined him. So that was a 6-3 decision. But I covered
those are aberrations.
Those were aberrations, and as we look forward to the court, particularly this term, when we will see important abortion cases, important affirmative action cases, where the conservatives are chomping at the bit to get back on top, and I think they will.
Jim, you don't disagree with any of that?
After all, Jeff said it all, but
He usually
I
does.
disagree with him that the Obamacare situation, the second time around, was a typographical error. The words established by the state and the entitlement to subsidies only, where it's established by the state, was really the plain meaning of what Congress wrote. And there's a lot of law that the court should not rewrite what the Congress says. Of course, had they not rewritten it, which is in fact what they did, had they not rewritten it, there would have been a disaster, an economic death spiral, the parade of horribles that the government said would undoubtedly ensue. And so I think really the first Obamacare case, where Roberts cast the deciding vote, where he himself felt it was unconstitutional, and when he himself said this is a bad piece of legislation that he didn't like. And the second Obamacare case, where Kennedy, who also thought it was a bad piece of legislation, voted it with the liberal side, so you had 6-3. I think in both of those cases, they were decided because of institutional reasons applicable to the court that had nothing to do with law. I think that Roberts did not want the court to be seen as overturning a major piece of legislation and a major program of the Obama administration. And I think that's what really informed his judgment, because as he testified in his confirmation hearings, he really hated the Lochner era in the Supreme Court, where conservative justices struck down progressive legislation in case after case after case, and both on the state level and, of course, Franklin Delano Roosevelt's New Deal legislation. He didn't like that, and in fact, he said it in opinions as well. He said it in the gay marriage opinion, that the court really should not make its decisions based on whether or not it likes the legislation, but based on law. But in the case of the two Obamacare cases, it made its decision based on what five justices, in the first case, five justices, including Roberts, so the four liberal justices, plus Roberts, who hung his hat on the taxing power, sustained the legislation, I think because institutionally he didn't want the court to stand in the way of the legislation. The second time around, I think having sustained the legislation, he did not want to really make it a dead letter by interpreting the statute in a way that it would nullify.
Let me come back from the weeds for a second and ask you this. Do either of you believe, really, that following the law is something easy to do? It's not, right? It's all a matter of interpretation. The statute is often not plain. That's why we have terms like originalist and, activist. It's not that simple, is it?
Well, it's not only not that simple, is that I don't even criticize the justices for applying an ideological prism to how they see these questions, because it's impossible to do otherwise. I mean, you see questions like, in settings like this, you often find people saying or expressing the views like, why does it have to be so political? Why can't they just do the law? Well, the answer is, I think, there is no legal answer to many of the questions that go before the Supreme Court. Does the Constitution protect a woman's right to an abortion? May a university consider race in admissions? You can't read the Constitution and come up with the right answer to those questions. Ruth Ginsburg and Antonin Scalia, the difference between them is not that one's smart and one's stupid, and one's honest and one's corrupt. The difference is they have different ways of looking at the Constitution, and they come to different conclusions as a result of that. But the problem is we view these cases as if the law can simply answer the question. And my view is these are largely political questions, and what you want in a justice is simply a justice who will apply his or her prism on the Constitution in a transparent, defensible way. But I'm not under any illusions that there is a correct answer to these questions.
Okay, but I mean, if the test is whether or not the prism through which the decision is written is defensible, that's a judgment, right?
Yes.
And different people have different views of that judgment.
Correct.
So if what you're saying is, well, we kind of know, Supreme Court is a political institution, it's the trope in what we say, then there's really nothing to be done, is there?
Yeah, elect a president who will appoint justices
Okay,
you like.
there you go.
Well,
So
they're really
no, but I mean, if there's no such thing as describing a decision as principled for all, rather principled through your own political filter, then Jeff's right, isn't he?
Well, no, because Justice Souter, who turned out to be a liberal justice after all, Republican appointed, spoke at Harvard in the commencement address, and he said that the Supreme Court is subject to criticism because it appears to be deciding cases not based on anything in the Constitution, but based on what the judges say it is. Now, that's nothing new, I agree. Charles Evans Hughes said the law is nothing but what the judges say it is. But as Jeff pointed out, we have a court that is not representative of the American people. We have all 9 of them are really very, very bright. There may be one exception.
And the American people are dumb.
No.
And
no, they are bright interpreters of the law, but they are unelected. There are no evangelicals, no Protestants, no one from Middle America, and they were all educated at Ivy League institutions, and they are making decisions which are going to bind the American people for decades to come, and these are policy decisions. So you have 2 doctrines that are at odds with each other, just as you said. You have Scalia has tried to fashion a doctrine which makes some sense in law, where he says you look at the text of the Constitution, and you look at the original meaning of the Constitution. That's why he's called an originalist. And the Constitution, he says, is dead. It's not dead, it's virtually dead. And you don't decide constitutional questions based on what we would like it to mean. We decide the constitutional questions based on the structure of the Constitution, the text, and decided decisions. This court has radically departed from decided decisions to reach the policy goals it wants. In a number of the cases, Citizens United, which you mentioned, overruled recent prior case law on campaign contribution. The latest abortion case was we go 2 back, was a switch after O'Connor left the court and Alito came on. So if changing judges, changing judges, I just want to say, if changing judges changes the law, what is law anyway?
Well, I mean, it's a body of statute that's passed by a legislature that's interpreted by a judiciary. And the question is, you would prefer, I guess, to say we need one evangelical, one this, one that, one that, one that. I mean, seriously, if you did that, I don't know whether it would be any more representative, as Jeff describes it, than what we have now. I mean, if you have 5
But as Robert said in his dissent in the gay marriage case, who do we think we are?
Right.
Who do we think we are?
See, this is. I'm sorry. Go ahead.
No.
Well, no. The question of judicial restraint is such an interesting one because basically all the judges, without regard to party, they always say we want to defer to the elected branches of government. We are unelected. We serve for life tenure. We are not representative of the public. We want to defer. But depending on your politics, you don't want to defer to things. And there was sort of a perfect petri dish for these competing goals. Like the conservatives, the Voting Rights Act was extended virtually unanimously in the House and Senate in 2006, signed by that notorious radical George W. Bush. And John Roberts
pledged to enforce it.
Right. John Roberts wrote a decision.
And it had been similarly
reauthorized
by 5
and Herbert Walker Bush. That's right. And even though it had been passed virtually unanimously by Congress, John Roberts wrote an opinion in a couple of years ago in the Shelby County case, striking down Section 4 and 5, essentially eviscerating the Voting Rights Act, which is a completely different and almost non-existent law anymore. Okay, the liberals struck down the Defense of Marriage Act, DOMA. Same term, decided, also passed by Congress virtually unanimously in the 90s. And the liberals were only too happy to throw that law out of a slow-moving caboose. So, this idea of deference to Congress depends on what you think of the underlying law. And so, yes, it's very nice for John Roberts to say, "Oh, I'm just an umpire, and I don't like the Lochner era, and I don't want to get in the way of Congress." And yes, I think that idea was behind, in part, his defense of the Affordable Care Act. But don't kid yourself, he was only too happy to get rid of the Voting Rights Act. He was only too happy to get rid of McCain-Feingold, also passed overwhelmingly by the Congress, the campaign finance law. So, and the liberals are only too happy to get rid of laws that discriminate against gay people or limit abortion rights. So, yes, they all want to defer to Congress, except when they disagree with what Congress did.
Okay, so you've described what from the outside would seem to be a completely dysfunctional system, right? You have
Compared
people...
to Congress?
No. Nothing compares with Congress. Nothing compares with Congress. But I mean, seriously, so some group, we call them Congress, passes laws. The language is never clear. The plain meaning of the language, as lawyers talk about it, is often not plain at all.
Established by the state is pretty clear.
Well, right.
Well,
no.
want to get into that.
No. Hold on. I'm not getting specific yet. But the point is, somebody has to adjudicate or interpret or decide whether your plain meaning is the same as yours, or which of yours, if they're in competition, should prevail. That's this group of people, right? So as Jeff says, or as you say, I forget which one of you, right now it's 5-4 Republican, and the best way to do it is to elect a Democratic president. I was going to leave this for later, but we'll get to it now, and then we'll come back to some other stuff. So isn't there a real argument to be made for ending life tenure for Supreme Court justices? Because you have a situation, well, for example, Tony Kennedy, who's now the swing vote, was appointed by Ronald Reagan, a president who no one has voted for in 3 decades. Is that any way to run a democracy? At the state level, we have election of judges. I think that stinks. But you have age-limited or term limits on judges. What's wrong with that in order to ensure a churn that might more accurately reflect where the country is?
Well, what's wrong with it is it'll never pass because it would require
I'm gonna ask you-
a constitutional
I know.
amendment. It's the same issue. I mean, why talk about something that can't happen? It would require 2/3 of the Congress and 3/4 of the states.
The simple answer is because I'm the moderator and I'm asking the question.
No. All right, but let's assume. Let's assume that you're.
I also went to
2/3
law
of the
school.
Congress
I
and 3/4 of the states.
know
How hard it is.
I know how onerous the process is.
And then you have Lawrence Tribe at Harvard saying you don't tinker with the Constitution. So who's going to come out other than Michael Kramer and say we ought to have term limits for Supreme Court
Everybody
justices?
here.
And
Jeff
All right,
Toobin.
so what's the argument?
Well, the argument is people shouldn't have jobs for 30 years in America, period. I mean, it's like, enough already with these people. I just think, and, we have a system now. The Constitution was passed in the late 18th century where people were expected to die in their 50s, right? And, we fortunately now live in a world where, the upper middle class people who are in the Supreme Court talent pool can all be expected reasonably to live well into their 80s. And so that now becomes a big part of why presidents appoint justices. I mean, when Barack Obama was considering Elena Kagan or Diane Wood to replace John Paul Stevens, just about the single deciding factor was that Elena Kagan was 10 years younger. And, all presidents think that way. Now, Stephen Breyer has an interesting response to this question when he gets asked about
Ending life tenure.
Life tenure or term, mandatory retirement or term limits. He says, I don't have a problem with either one, but you have to make sure that the Supreme Court is the last job people have. That you don't want to have Supreme Court justices angling for something else. There's a really interesting proposal by a couple of law professors that basically would create 18-year staggered terms every 2 years. So every president would get 2 appointments. It's a terrific idea, never going to happen in a million years, because, as Jim says, it would require amending the Constitution. And we have a two-party system, and so Democrats now that that a Democrat is in office, they like the idea of these long tenures.
Sure.
And so one party, because it's so difficult to amend the Constitution, can essentially veto.
All right, I don't want to go off on a complete tangent on this, but let me ask you because I don't know. Does Breyer get to the question of what you do with those justices who age out?
No, well, I think what happened. I think to the extent they do what they have always done, which is serve on lower appeals courts occasionally. Right. Justice Souter does it all the time on the First Circuit. Sandra Day OConnor.
But they're not becoming general counsel to Peter May's company, so they can make a lot of money, right?
Well, actually, Charles Whitaker, one of the worst justices who ever served on the court, went on to be general counsel of General Motors.
I didn't know that.
Yeah.
Okay.
However, you must bear in mind that Oliver Wendell Holmes in the 20th century served on the court until he was 90, died at age 91. Brandeis, productive until the very end. Brandeis served, I think, until he was 82. Ruth Bader Ginsburg said she was going to serve as long as Brandeis did, and that day came and left. And of course, the liberals are delighted that she's still on the court.
No, they're not. They're furious at her for not leaving while Obama is president.
Because he can't get a nominee through the Senate.
Of course they could.
Who?
They could get, Sri Srinivasan could get through the Senate tomorrow. Sri Srinivasan is a judge on the D.C. Circuit, young Indian American who served in the Solicitor General's office. I mean, the idea that Ruth Ginsburg is doing liberals some favor by staying on the Supreme Court is absurd. She should be gone if you are a liberal.
Right.
I
I read her opinions. I think she's doing the liberals a great favor. I think her dissent in Hobby Lobby was a masterpiece.
No. And when President Cruz replaces her, you won't think that.
Well, that's right. That's why you have to be very careful about your presidential vote, because obviously if Ted Cruz gets in or Huckabee or any of the others,
let me just say about that as the political journalist on the panel, or former political journalist, there has not been a campaign where somebody thought that the issue of the Supreme Court was going to be decisive or be a real factor, and it never is.
Never is. Never is. And I've asked all the political professionals about this, and they all say the same thing, Democrats and Republicans alike. They say, it's like, why don't people care about the Supreme Court? It's such an important issue. And they say, look, the people who really want Roe v. Wade overturned are going to vote Republican anyway. The people who really want Roe v. Wade maintained are going to vote Democrat anyway. And the people who are in the middle, the people who are going to decide presidential elections, don't care about the Supreme Court. The people we are appealing to, the people we are pitching our campaign to, just are not engaged with the subject. And if you look back to presidential debates, going back all the way to Reagan, there has always been one question in one debate about the Supreme Court, and they both say what you would expect, but
I'll follow. I want a justice who will follow the law.
Follow the law, and President George W. Bush liked to say, I want judges who will decide cases, not legislate from the bench, and Democrats say they wanted to protect women's rights, but it's just not an issue that grabs a lot of voters.
Okay, let me. I want to try before we open it up to you guys, who I'm sure have a lot to say about this and hopefully a lot of questions. I want to get to two issues that, again, interest me. First of all, do you think that there's any chance in the wake of Citizens United that the current court will in some way rein in what's become of campaign spending?
I think they authorized unlimited campaign spending because they thought at the time it benefited Republican candidates. They were the party out of power, and 5 Republican justices voted to have unlimited campaign spending. And what's come out of the decision is contributions from God knows where, with a lack of, in many cases, a lack of full disclosure as to who the contributors are. Clarence Thomas doesn't think that political contributors should ever have to reveal who they are. So I don't see the present court as reversing itself on Citizens United. And in fact, I think there's going to be...
Or chipping away at it.
Or even chipping away at it. But right now, I mean, look at the amounts of money that Hillary Clinton is raising, I think Democrats kind of like Citizens United because they think it's helping their free speech. So there's always the case with the Supreme Court. It's whose ox is
So
being
let me
bored.
just say, I saw Jeff blanch.
Yeah.
So Jeff,
He's always blanching.
No,
I know, it's true.
I think, Citizens United, there are two ideas at the core of it. One gets a lot of publicity, one doesn't. One was corporations are people. And you know what? That's true. There's nothing wrong with that idea. I work for the New Yorker. I work for CNN. We are always waving the First Amendment around. New York Times against Sullivan is a famous libel case about freedom of the press. New York Times is a corporation. The idea that corporations have First Amendment rights is not a particularly controversial notion. And if you notice, it's not even corporations who are giving a lot of money to political campaigns. It's almost all from individuals. The second idea is much more controversial and I think much more troubling. And that's the idea that money is speech. That giving money to a cause, to a candidate, is functionally equivalent to carrying a sign, to speaking in an auditorium. That's the idea that the Supreme Court has adopted in full with Citizens United and subsequent decisions like McCutcheon. And I think once you believe, as a majority of this court does, that money is speech, they are going to strike down more laws, not less. They are going to expand Citizens United, not contract it. So I don't see any reluctance on the part of this court to carry out what they view as the First Amendment's mandate to limit Congress or state legislatures from interfering with the speech that is the money of wealthy people.
okay, let's move from the First to the Fourth Amendment, my other interest here, and privacy generally. Some of you may know that in this term, the court said that a police officer could not search the cell phone of a person who is in custody having been arrested for a crime. Now, if he had a letter on him, something like that, they could look at that. You needed a warrant. You needed a warrant to search this cell phone. This is just an example of the court facing the new reality of privacy, of electronic growth. It also goes to some of the NSA and FBI surveillance cases, which are clearly going to come up. I mean, my bugaboo is that the pendulum will switch back when there is another attack or something, and people will say, no, we want everyone's phone bugged, because how else are we going to find the terrorists? Where do you see the court going in the privacy area?
Well, first place, what's interesting is the alignment of the court in Fourth Amendment cases, because the leading advocate for Fourth Amendment rights, ironically enough, is Antonin Scalia. Scalia reads the Constitution as prohibiting unreasonable searches and seizures without a warrant, period, full stop. And he extrapolates from that. Of course, there was no electronic surveillance, and there was no DNA swabbing at the time of the Constitution. And James Madison really would have been bug-eyed if he knew the kinds of searches that are engaged in by law enforcement today with technology. So he has voted to invalidate searches and seizures. Sometimes he's been in dissent. He was in the DNA case where the police took a buccal swab from the cheek of someone who was arrested for an unrelated crime, and then they traced the DNA to an unsolved rape that was about 6 years old somewhere else in the state of Maryland. Scalia was appalled. He said, does this mean every time there's a traffic stop, the police can stop you and take a buccal swab until they've built up a data bank of buccal swabs and DNA samples from all Americans, and then they can use that to track unsolved crimes or crimes to be committed? I mean, he's called that a brave new world. And sounds good to me. I think, here, Eugene Robinson of the Washington Post wrote a marvelous op-ed in which he said he never has had occasion to applaud Justice Scalia. But here he believes Justice Scalia was absolutely right.
I think actually the court is feeling its way through the privacy issues in a very defensible way. I mean, in particular, the phone search case, which Chief Justice Roberts wrote. I mean, if you think about it, if you were to search my home in Sherman, Connecticut for information about me, you would find next to nothing. But if you were to search my phone here, you would find out like my entire autobiography. I think Roberts recognized that, and all you have to do is get a warrant. It's not like you can't search it, and judges are not exactly reluctant to give warrants. So I don't really have a lot to criticize the court about in the issue of privacy. I think technology always creates new and difficult issues, and I think they're grappling with it in an intelligent way.
Either of you have any particular bugaboo in terms of issues themselves that you think are going to be really contentious in the next few years? Affirmative action, voting rights some more,
Well, we
anything
don't
else?
precisely know because, of course, the Supreme Court hears what it wants to hear, and a number of cases have been filed. We don't know whether they'll grant review, they call it cert, or not, but clearly an abortion case is going to come up. Clearly you have at least 4, possibly 5 justices that are poised to overrule Roe v. Wade.
Well, they've been poised to do that for 20 years.
Yeah, that's true, but they haven't quite gotten there, although they've been chipping away and hacking away at abortion rights whenever the issue has been presented. You referred to the case involving so-called abortion counseling.
Right.
Where it's appalling that a woman is going to a healthcare center for an abortion and a stranger approaches her and says, have you really considered your decision and have you thought about it? And have you considered all the alternatives? And 5 justices held that, at least 5 said that the so-called counselor had a free speech right to do it, although they couldn't do it in close proximity to the abortion center, but they had to do it within 50 yards of the abortion center.
Just to answer your question in a more political realm, I think, as historic as Barack Obama's election was in 2008, the midterm elections of 2010, I think, are going to loom almost as large historically, because you had this massive sweep of state legislatures in Republican hands that included all 3 branches of government in many of these states. And a significant part of what they did was tighten abortion restrictions in state after state, whether it was 20-week limits or creating very difficult rules for clinics to comply with. And they also limited voting rights, whether limiting absentee balloting or early balloting. And those cases are now working their way to the court. And I think that's where there's going to be a big conservative resurgence at the court next term, upholding basically any kind of regulation short of an outright ban on abortion, and limiting all sorts of restrictions on voting in the name of eliminating voter fraud, which does not exist.
Does not exist.
And eliminating affirmative action, which I think they're on the verge of doing.
That maybe.
Yeah.
Okay. Folks. Yes, Susan.
Given the fact that that was a basis through which Justice Kennedy provided the 5th vote, that at least that portion on disclosure.
No.
No.
Because the Supreme Court can't impose disclosure obligations. They can only uphold or reject disclosure obligations that a state legislature or Congress imposes. This Congress is not interested in any sort of campaign restrictions, so they are not going to pass any restrictions. And I think disclosure, by and large, 8 justices believe, except Justice Thomas, believe that disclosure is constitutional. But they can't impose them unless a legislature or Congress passes them first.
And just my last question, and this is a real quickie. Quick. Was there ever an assumption that there would be a federal exchange before some states refused to have a federal exchange in the health care law?
Of course. The entire law was based on the assumption that there would be a federal backstop exchange. I mean, again, I don't want to relitigate King versus Burwell here, but the position taken by the plaintiffs in King versus Burwell, that states that didn't have a federal exchange, you couldn't get subsidies in those states. In the course of a rather extensive debate in Congress, the most debated law of the past 20 years, not one member of Congress suggested that people in those other states couldn't get these subsidies. So that, to me, suggests it was a trumped-up, ridiculous lawsuit.
Okay. Yes.
Hi, my name is Megan McQuinney. In terms of changing the judicial process, do you foresee any possibility of changing prosecutorial immunity or judicial recusal in the Supreme Court?
Prosecutorial immunity.
You mean like suing prosecutors for bad behavior?
Yeah, or other, no.
John Paul Stevens
you look-
was a great advocate of abolishing immunity from suit for governments, and this was one of his great causes. And I think it's sort of vanished with him. And I got to say, I am never reluctant to criticize the Supreme Court. I don't think the recusal policies are bad at the court. I mean, it's basically a self-policing operation. But I haven't.
Have there been any instances that you think were egregious?
No, I don't think there have any been. I mean, there have been certain circumstances where people have filed amicus briefs, with companies that the justices own stock in. But if you were to prohibit that, you would just be able to invite amicus briefs from people whose stock. And you could game that system. I don't know. I just don't think they're corrupt. I don't think they're going to be corrupt. I think they're bad in certain respects,
That's
but
different.
I don't think they are corrupt.
Well, we did have an instance of arguable corruption, which was Abe Fortas. And we do have the fact that the justices of the Supreme Court are not bound by the federal canons of ethics applicable to the entire federal judiciary. And they say they'll read it, but they won't be bound by it. And as Justice Jackson said, we're not final because we're infallible. We're infallible because we're final.
Right.
So,
Which is a great. Yes, Bob. I forgot that.
you forgot that.
Well, right.
Don't forget it.
I'm trying to forget everything I learned in law school. Yes, stand up, please.
I'm Bob Barbanel. Given some of the notoriety,
It's
Or
not working.
just talk, put it closer to your mouth, Bob.
It is?
given some of the publicity and notoriety of recent decisions on both sides, and what many people think in the next presidential term, 3 or 4 Supreme Court appointments are likely to come up, do you think your point that no candidate will raise the Supreme Court as an issue will continue to hold?
Absolutely. People don't care enough. They should, but they don't.
And I think, by the way, that's been, the University of Michigan has some really good survey research as opposed to a lot of other places. They've asked this question, or they've explored this question quite a bit over the past half century, and it's never been otherwise. Yeah, I'm sorry, was there someone back here? Yes, oh, I'm sorry.
I'll talk loud. Rick Silverstein. I'd like a few words of what's really in Thomas's head.
February 6th. Keep an eye on the date, February 6th, 2016, coming at next term. That will be the 10th anniversary of the last time Justice Thomas asked a question. It'll be a decade. And you know, those of us who go to Supreme Court arguments frequently, you can't help but sit there and think, will this be the day? You know? Because it'll be such a big deal when it finally happens. And you know, there are not that many of them, and the courtroom isn't that big, and you think,
So,
it could happen.
all right, so you wait.
You know what? But the answer is, I think, unfortunately, and unfortunately for Clarence Thomas, his term has been defined by this silence. And in fact, he is not an insignificant or unimportant justice. I once went to a speech that Justice Scalia gave at a synagogue in New York, and someone asked an interesting question. They said, Justice Scalia, what's the difference between your judicial philosophy and Justice Thomas's? And he sort of talked around it for a while. He said, look, I'm an originalist, but I'm not a nut. And I think that sort of Justice Thomas, Jim was talking about the New Deal cases. Justice Thomas thinks those were incorrectly decided, that the Lochner era, that he is a pure originalist, that unless, James Madison really contemplated the issue, it's unconstitutional. And if you look at the Second Amendment, the right to keep and bear arms, which has been expanded, if you look at Citizens United, that approach to the First Amendment, those issues first came to the court's attention through concurring opinions and dissenting opinions of Justice Thomas. So he has brought into the Supreme Court's bloodstream some of its most conservative ideas. He hasn't written a lot of majority opinions because both Rehnquist and Roberts don't give him the big opinions because they know he won't keep
Then
them.
you're suggesting that intellectually, at least, he has serious influence.
Absolutely, absolutely.
So he may be a nut, but he's not dumb.
No. I think the idea that Justice Thomas is dumb or unqualified or not paying attention is completely wrong. Is just not a reflection of what's going on at the Supreme Court. It's based solely on this bizarre silence at oral argument, which is, has become a fetish of his that I think discredits what is otherwise a significant tenure at the court.
Well, he doesn't believe in full disclosure. We know that. So he's afraid if he says something, someone might draw an adverse inference. But my problem with Justice Thomas is that he was appointed to succeed Thurgood Marshall. And Thurgood Marshall certainly, you would say, voted in favor of black interests every time the issue was presented. And Justice Thomas seems to vote against black interests every time the issue is presented. And coming from what? Coming from a constitutional argument which is totally off the wall, which is based on natural law. You say it's based on James Madison. He goes back to Thomas Jefferson, and he goes back to the Declaration of Independence, and it says that we're endowed by our Creator with certain inalienable rights, including life, liberty, and the pursuit of happiness. And so he says, since it comes from God, it doesn't come from the government. And so since it doesn't come from the government can't confer dignity, as was Kennedy's argument in the gay marriage case. The government can't confer life, so therefore he's against capital punishment. And as Tribe says, no justice of the Supreme Court has evolved a theory of natural law in the last 50 years. So I don't say he's dumb. I just think he's off the wall, off the chart.
I'm running out of time.
I'm sorry for the question.
Well, no. I don't think it's fair to say Justice Thomas doesn't reflect, black interests. Black people think all sorts of different things. He has a view that integration and forced integration has actually hurt the black community in many respects more than it's helped. He thinks affirmative action is stigmatizing. I don't agree with what he's saying on those issues, but it's not like there is some monolithic black view that he is obligated to follow. I think he has a different view of what's in the interest of everyone.
Okay, Frank, do you have a question? I think
Sandra Day OConnor came to the library here in Kent some years ago.
The microphone.
Sandra Day OConnor came to the library here in Kent a few years ago, speaking on Sunday afternoon, packed house. She spoke wonderfully, and when she was asked what was the abiding impression she retained of the Supreme Court after her years there, she said that the impression she took away was the sincere zeal and hard work which the justices put in to managing the law for the American people. Discuss.
Thank you. Listen,
can I just say,
Yeah, please.
I think there is a lot to that view, and it contributes to a decision which I disagree with, but I can sort of understand, which is why there are no cameras in the Supreme Court. I think one of the things that all the justices have in common, and it is basically an admirable view, is they don't want to damage the institution. They don't want to leave the institution poorer for their having served there. And they are worried that cameras would somehow degrade and demean the institution. I don't agree, and I think, I am currently writing a book about the kidnapping of Patricia Hearst. So I'm thinking a lot about Stockholm Syndrome. And, Elena Kagan and Sonia Sotomayor, both in their confirmation hearings, said, I'd like to have cameras in the Supreme Court. Now, victims of Stockholm Syndrome, they're opposed to cameras in the courtroom because, they are now part of this institution. So I do admire the good faith of the justices and their interest in preserving the institution. I'm just not sure they always do it the right way.
Well, I
Go
think
ahead.
just as a footnote, polls say that 1/3 of the American people can't name a single justice of the Supreme Court. And I think that if you were to drill down more deeply, you would find that a much larger number have no idea what the Supreme Court does, what it's decided, or how it might affect their lives, even though those who've studied it know that it affects our lives profoundly. So the Supreme Court has almost an iconic significance, however, among the American people. Congress has an approval rating of 8%. The president has, I think, now an approval rating of 32%, which is about the same as the Supreme Court, although it's gyrated a little. I think with the gay marriage case, it spiked up a little bit. It was about 30% last year.
Obama's significantly up from that.
And Obama's significantly up from that, probably. But in any event, I think that most of the American people have said that they lack confidence in our basic institutions of government. So this is where we are right now.
I'm sorry, Jim. We're over our time. I wanted to ask one question and then make one comment. The question we were going to ask when we were in the room where we had the clickers involved term limits or age limits. So let me ask, just by a show of hands, how many people here, this is unspecified, I'm not saying 20 years, age 70 or something, how many of you would support age or term limits for Supreme Court justices? Yeah, I know. But let's just get this out of it. Okay. Who would not? All right, it's pretty much as I would say, unanimous. Ladies and gentlemen, I want to say one other thing. We're getting close to the end of this iteration of Kent Presents. Donna and Ben have done a fabulous job. We hope you've enjoyed it. Okay, one more anecdote I want to leave you with because I've always loved it. And you can use it anytime you're in a heated argument, or you could apply it after this. A long time ago, you correct me if I'm wrong, Justice Story and Justice Patterson almost came to blows in the court over some argument. And things were really dicey. It was at a time when there was a custom in the court that when it was raining in Washington, justices would have a drink. And in the middle of this argument, John Marshall, the great Chief Justice, said to his brethren, including Story and Patterson, he said, "Ladies and gentlemen, the jurisdiction of the United States Supreme Court extends the length and breadth of the land. It must be raining somewhere. Let's have a drink." So, go have one. Thank you very much, guys. I hope that was true, because I always love
I've heard versions
versions of that.